everyone who's tuning in. If you're logging on, all right, we are live. It's all working. All systems go. Okay, so welcome to our first Facebook Live for 2025. I am Tara Lucke, founder of The Art of Estate Planning, and I am joined by my partner in crime, Carrie Payne. And
that's a better intro, Tara.
Partner in estates, we're not committing any real crimes, grave digging, nothing like that. But, as exciting as it gets, it's all about cost agreements. So we are thrilled to be bringing you this topic, which is essential clauses for your estate planning cost agreements. And before you just fall asleep or tune out because it sounds like a pretty dry topic, we are here to tell you that this is hopefully very interesting and relevant, but also essential, because this affects every single one of your estate planning matters for the life of your business. So in reality, we really think that sorting this out and getting on top of your essential clauses is the gift that keeps on giving. Your future self is going to thank you for going through this process and paying attention today. So we've got the presentation for you to help with taking notes. You don't have to scribble everything down. We actually have a sort of 2-pager checklist that you can download, which has like the headline points. So Carrie is obviously going to elaborate in depth on all of those points, but I will post the link to download that checklist in the chat, so you can download that, and then at least you've got a reference point of the things so that you can go and do a bit of an audit against what you're currently doing. Now, I don't want to steal too much of Carrie's thunder, so I will hand over to you, Carrie. Welcome.
Thanks, Tara. I want to do an acknowledgement. So we're acknowledging that we're hosting the training. Well, I'm hosting the training from the lands of the Turrbal and Yagara people here in Brisbane. I also acknowledge the traditional custodians of the lands on which each of you are living, learning and working from today. I pay my respects to elders past, present and emerging, and celebrate the diversity of Aboriginal and Torres Strait Islander peoples and their ongoing cultures and connections to the lands and waters of Australia. Now, I think when we started sort of talking about this as a topic, it kind of became organic, because there were lots of requests or suggestions about this, given the issues we were dealing with in the TT Precedents Club. And then as that kind of evolved, we're now sort of formulating it into a process that can help people identify, what exactly we're trying to do with a costs agreement. So, when we talk about it, the first thing we're going to talk about is what the actual purpose of it is. Obviously, we're going to delve into the essential clauses. We're going to talk a little bit about ethics and things to consider when actually applying some of those clauses, and then some considerations for how you actually deliver those cost agreement terms. So I made this little slide up in Canva. I'm wasted on law, guys. Should have been in design, I think, whenever I use something like Canva. So this is one of those phrases that I've heard Tara use that I think is so applicable. This is supposed to be about what the purpose of a costs agreement is. So when we start talking about costs agreement, it's not necessarily a sword to be used against your clients. And it's also not necessarily a shield to be used for you either. Yes, it certainly is that as well, but I believe it's somewhere in the middle, in that, you're helping your clients to understand exactly what you're going to be doing for them. And in that process, you are protecting yourself as well. So when we talk about the purpose of a costs agreement, it's not about, yes, we have to, as lawyers, communicate what the terms of our services are. But in doing that, clearly we are helping our client, because if you're saying to them, I'm not doing X, Y, Z, and they want X, Y, Z, they will then be able to know that they have to go and get other advice. So Tara, I didn't know if you have anything to add onto that, but I just think that when we talk about that, the purpose of a costs agreement, I know some people have gone, I don't want to create really long terms for my clients to read. that's okay. We understand what you're saying, and we're going to talk a little bit about at the end how you can deliver that in a way that makes sense for a client. But I think in not saying some of this stuff, you're not actually being kind to your client.
Totally. I mean, setting expectations from the very beginning is a great idea. And I just think the cost agreement, it's always there in reserve, and having an up-to-date cost agreement where things are set out with clarity, I think it just, moves you from being on the back foot to being on the front foot and being like, oh, well, here's our clear position. It's been clear from the very beginning.
Yes. Yeah. So I think that's what I wanted to kind of get across first, is that this purpose of a cost agreement is not about punishing your client with really long legal words that aren't going to be friendly at all. It is actually the friendlier position to really carefully scope out exactly what are you going to do to help them. So then they have options to know what they have to do in response to that. If you feel differently, please let me know. If you've got our cost agreement terms and you want to talk about any of them, please feel free to email us at hello@theartofestatePlanning. If you've got any questions about cost agreements too, I should say too, this is a live, so please feel free to put your comments in, particularly if you disagree with me about this particular point, because I think that we are going to have some people that don't like the lengthy legal stuff. I want to hear and work out how we can work together to make it a better solution for you and your clients. All right, let's get into the actual fun stuff. So what are we all here for? What do we want to know that we think needs to be in your costs agreement clauses? So we're going to be talking here about what we've got in our costs agreement precedent. My brain is already a hive of ideas for version 2.0. As you know, in the Art of Estate Planning, we are really passionate about continuing to change and grow and adapt our services based on real-time feedback from the industry. And so, if you're a part of our TT Precedents Club, these updates are something that do come as a freebie, so to speak, if you're a part of that club. If not, you can join for a month to get that update. But these are the ones that are currently in there. I want to tell you, though, it's going to be a live document. We're going to be always looking for ways for you to do the best or deliver the best service for your client. Tara, this one, I think that this came up actually as a TT Precedents Club hot seat discussion, and it was a common theme, and I think we have to thank Megan Clark from our WA constituent for this being a very important thing. It was basically number one on our list, I believe, to go into the costs agreement clauses, when we're acting for couples, because it is something that is very kind of common in estate planning, not so much in other areas of law, when we're acting for couples. So when you're acting for couples, we all know about the issues as a lawyer. I kind of explained to clients in our meeting that, as lawyers, there's really only a small handful of things that we can do that get us removed as lawyers. And the kind of overriding obligation we have is to do whatever's in the best interest of our client, which is really easy when it's one person. Not so clear when it's two people. So we want to make sure that in the event that something happens that you feel that you can no longer act in a joint scenario, so jointly best interest for both of them, we want to give you the tools. So the actual terms of the costs agreement, when we talk about this joint part, what I want you to do is use this as a bit of a checklist. So, do you have something that talks about when you're acting for clients jointly, making it really clear that it is a joint appointment, okay? That includes talking about how you have to communicate with the people jointly, meaning that, partner A can't pick up the phone and have a unilateral conversation with you that excludes partner B, because that makes it more difficult for you to be sure you're acting for people jointly. Our cost agreement terms also talks about what actually happens when there is a conflict arising for you, so what the actions are, what the consequences are for the client. So they understand that, number one, you can't act. They might have to go get separate advice, and effectively that there are fees that might be incurred in going and getting that separate advice. The final thing is also the elephant in the room about what happens about anything that you've already done. And so just addressing that, they still have to cover the costs of what you've done to that date. So I think that this is something that is very, overlooked when we do estate planning to get real clarity on. Tara, I didn't know if you had anything to add to that, but I just think that was our number one item to go with the costs agreement.
Yeah, I think it actually initiated the idea of a cost agreement terms template, because we just had a string of them coming through the TT Precedents Club where, lawyers are like, do I have to disengage from the whole process here? Like, one spouse is secretly calling me saying, oh, I want you to put this in my will and don't tell the other one. Or, I still remember like a matter that I was working on as a junior lawyer years and years ago, where we had like 3 or 4 meetings because it was a complex matter. And then in the very last meeting, while the wife was in the toilet, the husband said, would this change anything if I had a child that my wife didn't know about? And you just think, oh my, so no one wants that to happen in their matter, right? But at least if it's clear and you do have to extract yourself and declare the conflict, you've got the process for you to follow, and you told them from the beginning, and you've got something in writing to point to them. And obviously they're probably going to be disappointed or frustrated, but you're protected.
Yeah.
So anyway, if everyone's got any other doozies they want to share in the comments, obviously just keep it high level, not specific.
I saved that story that you've told me, Tara, and I use that as one of my anecdotes when I'm explaining, the importance that I have this in my slide for one of my meetings, like really clear again, who are we acting for? Because it is so important. If you've got a costs agreement, you're doing estate planning and you haven't covered stuff about acting jointly, this is the time. So the next one, and I don't know if this is second in the actual, but it was certainly second in my mind for a variety of reasons, is about secure storage. So when we talk about secure storage, and I use the term secure storage, obviously safe custody, interchangeable terms, and I do believe, Tara, we do have variables in the precedent that allow you to pick what your terminology is to match the rest of your kind of branding, so to speak. But when we talk about this secure storage, I want to break it down into a few elements here. Number one, how long are you keeping the documents for? Okay, if you're doing a fixed fee approach, are you going to keep those documents indefinitely and the costs associated with keeping that? If you're not, you need to communicate that with your client as a part of your fixed fee service. Okay. I think that's really important because me personally, I've had to go out and get more safe custody storage solutions just in my own small firm after 4 years. I can't even imagine if you're running a bigger firm what those costs are. I remember another estate lawyer saying to me that they had a will bank of a large industrial shed out somewhere, and I thought, that's not an asset, that's a liability. So I think, when you're talking about this storage, make sure that you're communicating clearly to your client. If it's a part of a fixed fee arrangement, how long are you agreeing to actually store these documents for? I think too, this is probably something that, Tara, you might have a bit more history here, but certainly what your obligations are around notifying other people about where those documents are, including in the instance that you've passed away. So I still think it's wild that we don't have like a national kind of register of, number one, documents. Number two, when someone passes away, it's not easy to actually find out that someone has died. And so, because of that complexity of being across everything for all of your clients, we want to make it clear that it's not up to you to actually be, scanning death notices and communicating things. So, getting clear in your costs agreement around who's notifying the controllers, where the documents are, and who's actually notifying anybody if they've found out that you've passed away. Okay. This next one is a passion pain of mine. When I started it, I'd already kind of half drafted these into my own costs agreement because of how much pain and suffering it had caused me. Is, actually organising the release of any documents that you've got in your secure storage. So when we're talking about release, I'm talking about release under multiple circumstances here, okay? So, request by the client themselves if they've got a new lawyer or for whatever reason they want to store the documents themselves. Request by one of the controllers, whether it be an executor of the estate or an attorney seeking to rely on a document that you've provided for the client. And also release to another law firm as well. So, getting it right in your costs agreement about what you're going to require to see from these people to actually release the documents, and also any costs that you think might be associated with that. Who wears that? Are you comfortable that you wear it? If you're not, you've got to make sure the client knows that there might be a cost associated with that, because there is a cost. Whether you're happy to pay it or not is up to you. But, by the time you get it out, not everybody has a safe in their office. Sometimes it is with a third-party provider and there is a retrieval fee. There is a cost, a time cost or a physical cost associated with that. We want to make sure that you're pretty clear if it's covered by you or if it's covered by the client. I also have included in that costs agreement what happens if the client wants the documents and there's fees still outstanding that are owed to you. We're going to talk a little bit about that in the context of ethics later on, but certainly making it clear around, hey, if you've got outstanding fees, this is the position. So if you are doing secure storage for your clients and you haven't got a really watertight secure storage process that is clear to the client, I think from the beginning, I think it's also very prudent to remind them of those secure storage processes at the end of the matter. But I think from the beginning, they want to know, hey, does this cost I'm paying you include the cost of storing the document? Okay. Tara, did you have anything to add there? Or?
We've just got in there some wording around, like the attorney's entitlement to the original will of the client. And, our policy is usually the attorney is not entitled to that, but obviously, that is subject to the ethics guidance from your respective law societies. And then also, just getting us off the hook if we decide it is appropriate to release it. We've basically said, like, we're entitled to release it if we, considering everything, do deem it's appropriate. So just like things to protect the firm a little bit. And I guess on that note too, like just making it abundantly clear, like, if you're asking for things to be transferred to other firms or like that there will be a fee and that this is the cost and, like we've done the disclosure from the very beginning.
And I think too, Tara, we're not talking about charging squillions of dollars here. Again, that's an ethics considerations we'll talk about later on. But as I said, there is a cost. We want to make sure that it's clear who's covering that.
Yeah, I'm thinking especially, like sole practitioner firms or boutique firms who don't have, like the powerhouse resource behind them to do all of the scanning and the copying, and that there is a real cost on the firm and the principal having to go through that process. And by putting it into your cost agreement, it also just forces you to think about it before you're caught up in the emotion of a particular request, and that you've made like a policy for the firm just generally.
Yeah, and I think if you don't have a policy, that costs agreement is a really great place to start to help build it out for you.
Yeah.
All right. Have we got any comments, Tara? I'm worried we're going to have the lawyers shouting in the comments. So I'm happy to hear them if we do.
Oh, we have actually. What's the best way to store the will? Bind the will or keep all the pages loose in a plastic sleeve?
Tara, I know this is your love language, is binding wills. This is something that Tara gets really excited about.
Okay, yeah. This is not quite on cost agreements, but I'm happy to have a little chat about it. Look, I think it gets really risky when wills are not bound. and you're like dealing with it. Like the best practice and least risky approach is that the testator signs a bound up will, right? And then when you are copying them, you are not pulling it apart and messing, because if there's any evidence of tampering, of staples being put in and out, or other binding methods going in and out, suddenly you're creating a headache on the administration side, where someone might say, well, what's happened here and why have we got this evidence? So I have done a whole video, which I'll put in the comments, about my preferred binding method, which is affordable and cheap and easy to do and still looks really professional, and also how I think you should tackle the scanning method as well. So I won't delay us here, but I'll put that in the chat. I think, any other way of like loose pages and whatever is sort of getting into the yes, you could do it, but it's a bit dodgy realm that we can't endorse. But whatever you do behind closed doors, then go ahead and do. But I'll put I'll put the link to this video that I think is worth a watch, just to see give you some food for thought.
We have discussed it in the TT Precedents Club a few times as well. So if you're wanting to find out the ins and outs of what the community thought, join for a month, have a look through some of the previous hot seats, because everyone's got their own opinion on how they do that.
Yeah, and actually Melissa is in the TT Precedents Club hot seat. So if you search like binding in the hot seat replays in the portal, Melissa, you'll see where we've all talked about it, and everyone, a lot of our members like the single staple with the corner, and they get we've got a supplier for our customized corners, and so you can hear all about that as well.
All right. Timely to talk about delays then, Tara. So I want to keep us on the tight schedule that we like. Estate planning is one of those areas of law that is a slow burn. Okay, it's not transactional, meaning they're not often a real driver for people. I sort of say there are some triggers, like some people, if they're rushing to go overseas, they think they're going to die on a plane rather than on the M1 driving down to the Gold Coast. So there's sometimes those drivers, but it's a slow burn most of the time. So when we talk about those delays, they can really not only eat necessarily into profit margin, but also just eat at your ability to stay on top of what your obligations are. And create more risk for you. So what we're talking about, I put the wrong slide in here, goodness me. What we're talking about when we talk about delays is we want to make sure that, you're thinking about how long the client has to respond to you on certain things. Okay, so this is everything from signing off documents, we're going to talk about that in a bit more detail later on, to just not giving you instructions to actually draft documents, or they've signed the cost agreement, they've not booked in a meeting, those sorts of things. So we want to make sure that you're thinking sort of comprehensively about the timeframes, but also the actual intervals at which you're going to do things like follow-ups. So our costs agreement is really trying to give you the protection that the client is clear that there are these timeframes applied, this is what you're going to do. And then also, Tara, forgive me if I'm wrong, I know I wrote most of the precedents, but also, and this will come into scope, how long you're actually going to have this procedure apply to this particular cost term. So if you've said you're going to do the work at $2,000, that includes a nice, testamentary trust will for a client, and then they come back 2 years later and say, oh yeah, I want to continue this now, your prices aren't going to be the same, okay, because things have increased. So, we're trying here to protect you, to make sure that your profit margin is still going to be keeping up with what's appropriate for you and your firm, but also that from a risk perspective, the client is aware that there's this tick in the background, and so you're not on the hook if they don't get things done and something happens to them. Tara, did you have anything you wanted to add to that part?
Yeah, look, I mean, we just set in time frames for all parts of the matter. So getting your instructions, like them accepting the fee quote, and then the instructions and then the signing, and just the whole way through, we're like, here's what we're going to do, but here's what you're going to do as well. And just, like I've moved law firms several times, and then people come back and say, oh, are you still going to honor that quote? And you're like, this is just an easy way to go. Like, especially if you feel awkward about it, to just go, oh, sorry, it expired. And we'll talk about the other resources in our pricing toolkit that the cost agreement precedent comes in. But, we recommend putting on the front page of your price list as well, valid for X days, so that it's just really clear. Like you said, as you said, clear is kind.
Yeah. And I think too, just even any additional costs that might come up as a result of those delays, making the client clear that if those do increase, even just something simple as a disbursement, if you've quoted, a disbursement is $50 and the client took 6 months to come back to you, and then now the titles office fee has increased, that's something they have to be aware of. So I think when we're talking about additional costs, again, that concept of making the client clear on what that position is. We are going to come back to that in a little bit more detail, because there are some other things towards the end of the matter that we're going to be talking about. But what I want to move on to now is something that's really dear to my heart, because I do a lot of work with third parties communicating instructions on behalf of clients. So when we're talking about third parties, though, I want to think about it more broadly, whether you're working through an advisor, with an advisor, or even just receiving information to and sending receiving information from and sending information to say the client's accountant. We want to make sure that you're really protected in what you're doing, and the client is really clear on what that actually involves. So number one, looking at, it's clear that if the client has given you the approval and the authority to act through this third party or to communicate with this third party, how that works. Okay, so giving you that protection that if they've said you can talk to this person, that you can talk to that person. Making it really clear too on, those communication channels. Okay, so, are you communicating directly with them, or are you going through this third party? And, the risks that are associated with that, making sure that we're protecting you against that. Really importantly too, about when that approval and authority ends. Okay, so the client making sure that they're aware that they have this positive obligation to let you know when they no longer want to communicate with this third party. So if you've been sent someone through a financial planner and that client disengages with that financial planner and you're still communicating with them, it's making it clear that if that client wants you to stop communicating with that person, that it's the onus is on them to let you know. This one was a bit of a 11th hour consideration for me, because it came up with something, but this concept of legal privilege. So I added this one in, as I think it might have been the last one I added, because it came up for me and I thought, actually, this is really important. And why had I not thought about it before? But this concept of legal privilege. So because we are dealing in the realm of things like asset protection, taxation, those things that intertwine with estate planning, if you're doing something for the sole purpose of, hiding money or helping the client avoid certain issues, if you have given information to the, say, the accountant saying, hey, we're doing X, Y, Z, the client really needs to understand what legal privilege is and what happens when you communicate with that third party. I think that, a lot of people don't consider that in estate planning, because we do feel that it's not necessarily something that applies to us as much, compared to other areas of law. But there are elements that do apply. And I think it's really important that the client understands that potentially communicating with a third party may or may not leave that umbrella of protection under legal privilege. Tara, did you have anything to add there? Or?
Well, yeah, just you don't want to be on the hook down the line for waiving legal professional privilege on behalf of the client without telling them about it and the consequences. It's probably unlikely, but like if if it's like, oh, it would have been really good to have professional privilege over this letter of advice, but we've sent it straight to the financial advisor and waived privilege without thinking about it, at least here we're like, well, you've told us to liaise with your advisor, so we're going to waive privilege when we do that, so you're off the hook. I think the other one too is like when you're getting instructions, particularly like from a financial advisor on behalf of a client, it's unless you've sort of set out the parameters of how you're working with them, you don't want anyone turning around down the track and saying, well, those instructions came from the advisor and your client is the testator, and on what basis did you go and prepare documents based on the instructions that came from the advisor? And that can arise, if you think about where the advisor is doing an initial conversation and facilitating like the starting point of the estate plan and filling in a instruction form and sending it to the lawyer, or even, where the advisor may not have such a key role in the process, but you're liaising with them about what to do with the super nomination. And they just email you and say, oh yeah, I think a super nomination doing this would make sense. And then you prepare the nomination on that basis. Well, you haven't received the instructions from your client necessarily. So, the wording we've put in there about engaging with that third party is really just to protect you and say instructions coming from that third party professional can be deemed to be the client's instructions too.
Yeah. I think that's a really nice segue, Tara, to our next point, which is about scope of work. So this is something that I think the lawyers will already get a bit of an idea about why it's so important. But I think, and I've got a really simple slide here, but really what we're focusing here on what's in and what's out. Okay. Now, what we mean by what's in and what's out, obviously you might think, oh, that's really simple. It's just we're doing this. But I don't think we've really explored that very deeply in a lot of scenarios. So why I thought this was a good segue, Tara, we talked about this, I think on one of our recent podcasts, about things like superannuation funds are now moving away from what they're calling binding death benefit nominations under one section of the superannuation law and going towards these lapsing and binding nominations. And it's a whole separate section of the superannuation law. But there'll sometimes be this hidden wording in that superannuation fund's trust deed that says that they have ultimate discretion, even if it's called binding on all the paperwork. So when we talk about this sort of stuff, are you actually looking at those terms for each of the retail funds for each of your clients? Are you doing the work to actually do that? If not, this is where the protection comes in. I think superannuation is a real sleeper issue for scope of work for estate planning lawyers for that particular reason, because there was a case I saw at the Superannuation Complaints Tribunal where there was this complete overriding of what was seen as being a binding nomination because there was an ultimate discretion to the trustee of the super fund. And so if you're just preparing a binding nomination form for a client because that's what Macquarie or whatever has available on their website as binding, is the risk on you that if it's actually not truly binding? So I think when we talk about this scope of work, we've got a really clear kind of list of things that, we want you to consider each time about whether this is in your services or not in your services.
And Carrie, can I just jump in with another super thing that has been brought up in the TT Precedents Club, where does the line end about the super nomination, so who's responsible for sending off the form to that industry or public offer fund? And then what happens if they reply back, send a letter out saying, sorry, you've done something wrong or we're not accepting it? And who's responsible, especially if it goes to the client and it's just sitting in an envelope on their desk or their kitchen drawer that they never open, and you, the lawyer, obviously never get communication about that? Are you on the hook for that or not? So we're really drawing a line in the sand about who's responsible for what when it comes to super nominations.
Yeah. You've kind of stolen my thunder. I'm sort of adding that into a topic later. But this is the whole point, is that, this scope of work, we're trying to find the detail for you about some of these issues that can have really, really big risk effects. And we want to make sure that if you're charging a modest fee, that your scope of work reflects that modest fee, okay? We also
like if a home is going into a testamentary trust under your plan, are you responsible for giving land tax advice about the principal place of residence land tax exemption for the beneficiaries? Most of us think when we're doing the estate plan that we are not giving land tax advice. Who even knows anything about land tax? But, so you've just got to like make sure it's super clear so your insurer knows it's out of scope.
I think the second part that we've got here really came up again in the TT Precedents Club is when you have repeat clients coming in, and we'll talk about this in a bit more detail about sort of extra additions to changes, but also just changes in what you're currently doing as well. So when we talk about changes, if the client actually says to you, hey, actually, I do want you to go and look at this superannuation deed in some detail, making it really clear to the client that if it's not in here and you want us to do it, then obviously additional costs are going to apply. So this one, Tara, I'm allergic to numbers, so this isn't necessarily my particular strong point, but I do know that, again, this really ties back to that clear communication is kind. And you might find in your existing costs agreement that you might have something about this anyway, but it was coming up in a few questions that we had. So we thought, listen, estate planning is often a fixed fee. And so we want to help our clients make it really clear about the invoicing intervals and how to do that. So, how often are you going to invoice? Is it going to be at the end of each month? Is it, at certain sort of junctures through the actual workflow of your matter? All right. How you're going to invoice for disbursements, is that just bundled into one of your invoices at certain junctures, or is it when it occurs? So, for example, if it's a high invoice that you're a small firm, you're running on tight numbers, can you invoice for that disbursement, basically when you incur that? Making it really clear the repayment terms, okay? So, length of repayment time and when an invoice is actually deemed to be issued. And then how we actually manage any unpaid fees. So I'm not going to spend a huge amount of time on this one because I think that a lot of people will have some clauses like this already in their costs agreement, but I think it does tie really important into that clear communication is kind. And also, I've recently been through the Queensland Law Society's random trust audit process, and they want to see this stuff. So, if you've got it in your costs agreement, that's kind of a tick, okay? Alrighty, errors and changes. Oh, lordy. I think we've got a whole podcast on this one, Tara. But
yeah.
If you're in estate planning, the pain of a client remembering that their brother has a middle name and they've only told you once you get to the actual signing meeting. This is something that is just, it sucks the love out of your job and also can really suck the profit out of the work that you're doing as well. So when we're talking about this concept of errors and changes, okay, I want to make it really, really clear that, you have the discretion about whether to charge for these issues. We'll talk about that again when we come to ethics, but I think that the client needs some incentive to actually do the work in the front end. And also you need the protection that if they've not done the work that you're covered. I mean, you might think, oh, it's just a middle name, I'll just go and insert. And that's great. If that's all the changes and you're happy to make that change, go and do that, okay? But if it's things like, I know the Queensland power of attorney document, if it's a small change, you can all of a sudden be having to add additional pages, having to change numbers in the document, tick certain boxes. With changes to documents that are manual and made in sort of on the fly, so to speak, before a meeting, these increase the risk of errors by you and increase your risk. So when we talk about errors and changes, what our costs agreement does is it makes it really clear to the client that if there are errors that are on their part or changes that they're requesting at the 11th hour, what the consequence for them is as a result of that. Okay. Tara, I don't know if you want to add anything in there. I know that we've just had a really enthralling podcast come out about issues with documents, but certainly I think that when we talk about this, it is something that I personally find just sucks the love out of my job.
Oh, absolutely. It's just, yeah, it's not what we're here to be doing, and it erodes into your profit. And, I feel like it's hard to be assertive about it as well. So, yeah. That's just clear as kind communication.
That's right. This one is probably, I think it might have been more me. And then I think, I'm not sure where it kind of came from, but I feel like it came from me because of a pain point. When we talk about giving clients documents, we want to make it really clear about what that actually includes. And bear with me, I know this is really enthralling stuff, but we've all had that client that goes, oh, can you give me the document in a Word version? Okay. Now, when we talk about what that Word version is, you might say to us, oh, just, give it to them anyway, because otherwise they'll just get it into a PDF and OCR it and print it out. Great. I reckon if they're that committed to the cause, let them do it. But I think that any document that leaves your office should be a PDF. Ideally, obviously, letters of wishes are our exception to that rule. But when we talk about that, there's a reason we're saying this, okay? We're saying, to the client, we're only giving them in PDFs, making it really clear from the beginning. And also, if you make changes to our document, we're not on the hook for those, okay? So the client that does go and PDF and OCR it and change it themselves, if you do make those changes, we're not on the hook for it. I have seen this, Tara, I don't know if you have any war stories, but there was a lady who had done it. She'd gone and OCR'd the document. She was a lawyer, OCR'd the document and then made her changes in tracking. Now, number one, OCR isn't like a perfect conversion. Number two, I also just think, my concern is, can they also do that after you've signed the documents? So if you've got a client that, you get everything signed up, you think you've done a wacko-do job, and then they come along and go, okay, 6 months after it, I'm just going to go in and, I don't want any more money. I don't want to get charged more money for changing this executor. So I'm just going to go in and change the document myself. It might still have your branding on it. So you've got to be really clear that this is the document we sent out and this is the document that applies. And if you make any changes, it's not you on the hook, it's them. The second thing is just, again, this is probably a bit of a passion point, is, what's actually being delivered to the client in terms of a document. If you're doing a fixed price for a client and your fixed pricing is based on efficiencies like standard terminology in your document. So if you've got a testamentary trust will, are you going to go through and manually kind of make tailored changes to that for the client? Is that included in your scope of work or not? Our assumption was that it wasn't for most people. And so what we've done is we've included wording around, hey, when we give you these documents, the price is based on us sort of having these standard terms. And if you want tailored changes to those standard terms, the price might change. This happens more frequently than I would like it to. So that was why I wanted to get on the front foot there. And I know there are a lot of people in our community suffering under the same problem. Future changes, I know we touched on this slightly before, but we had someone in the group said, what about if a good client does come back and they just want this one kind of small change to their document, like an executor role? So, what I wanted to do with that costs agreement is make sure that it was clear whether they were or weren't included, any changes after the documents had been signed. We've given you an option in the costs agreement as to whether you want to disclose the pricing of small changes. So, if you're the sort of person, I know there were some people when we talked about it in the TT Precedents Club, they did want to talk about or give some indicative prices. And then also a bit of sort of education for the client themselves about, what kind of change they want might actually affect what you have to do. So they might think, oh, I just want to add this extra attorney. And as I said, in Queensland, that can mean having to totally redraft the document. So I think, a bit of education for the client, the option to disclose some pricing, and also just making it really clear that, once we've kind of got those signed documents, anything that you come along with after is in addition to that pricing. All right. The next one we talk about is copies of documents. So this is getting clients versions of their documents after everything's kind of been done. So I live a very much electronic life. I think I nearly died when Optus was out last year. And when my power went out the other day. So I love electronic documents, but there are always going to be clients that for some reason want that hard copy version, okay? So when we talk about your services, if the client does request hard copies, again, there's a cost associated with it, whether you appreciate it or not. Is that included in your cost agreement? Is it included in your scope of work? We want to make it clear to the client. And probably my least favorite request is a certified copy. Okay, I've got reasons for why I don't like certified copies, which is a whole other discussion point. But again, that cost of actually certifying, a 40-page trust deed will. So testamentary trust will. I think that, again, there is a cost associated with it. Is it going to be borne by you, or is the client aware that it's an extra cost if they want those? Charging and commission. Okay, so, we do have in our standard precedents, Tara, forgive me if I'm wrong, an ability for our executors and trustees to actually charge fees for the services that they're doing. So we're putting in from the very start an acknowledgement for the client to understand that these are in our terms, and kind of by consenting to this, you're including that. So then they have the option to communicate with us whether they don't want that, and we know that from the beginning then. There's a bit of an education piece for the client about, the reasonableness of fees, so that they're understanding that if we're saying they can charge fees, they're not, they can't go charge squillions of dollars. It's giving them some comfort that the charging of fees is something that has to be reasonable. And finally, Tara, I know this is something that we wanted to create for our Victorian contingent in particular. There is actually a template document that people can use as a separate kind of acknowledgement by the client of those charging clauses, because the feedback we were getting is that the registrar down at the probate office in Victoria was kind of requisitioning people who had charging clauses in their wills, and there was no kind of evidence that the client had consented to those pursuant to a particular point of law. So we put that in for Victoria. I think it's also really a really good resource if the client is appointing your firm in those roles as well. We talk a little bit about there's some user notes in our cost agreement precedent that kind of gives you some guidance around other things to consider in that scenario. So if you're looking for that, I think that's a bit of a winner, that document. Following up and final signing. So you've done all the hard work, you've drafted these beautiful documents, okay, and the client goes silent. Okay, so we've had that position before. I think that, again, this is a risk point still for you. So similar to what we were talking about at the start, talking to the client around how many times you're going to follow them up, if there's any additional costs, if they want us to keep chasing them, if that sort of expires at a certain point, including just a position around, like, if their circumstances change or the law changes, you want to make it really clear that if they come back 2 years later and want to sign the documents you've already drafted, no, those documents no longer are appropriate potentially. So, and then also just a nod to our obligations to remind the client around what happens if you don't have valid documents in place. So again, there's obviously some noise around this in terms of ethics, but I think it's a really good reminder for the client. Third-party signatures. We've all been there with powers of attorney and appointing people, getting them to accept their appointments. We want you to help you make sure that the client is clear as to whether you're actually helping get those third-party signatures, okay? Or is it something that is on them if it's a part of the process? Additional costs, so if you are going to help them, that it is something that is going to be in addition potentially to what you're doing. And also just some, really clear points around if the client takes the document with them, or if you post the document pursuant to the client's instructions, that risk ends for you at that point. I've had scenarios where Australia Post has lost documents for weeks on end, or they come in damaged. It's not necessarily fair that you have to wear that cost, so making the client aware that it might be something that creates additional costs for them. This one, Tara, I think was the part we're talking about with super, but also with powers of attorney. So, we're talking about registering those documents with third parties like, the Land Titles Office, if you're in a state that requires that, or if you're doing it as a request from the client, if you're lodging documents with superannuation funds, making the client clear about who's actually responsible for that. And again, if you want to do it, you can amend it to make sure it's clear, but the client does need to know who bears the cost of actually doing that. Okay, so again, if there's costs associated, there will be a cost, whether you're acknowledging it or not. Is it something you're happy to wear, or is it something for the client? What happens, as we said before, if those aren't accepted? So if there's some issue with the document that's got nothing to do with you, what happens? Is it something that you're going to keep pursuing for the client, or is it something they have to kind of continue the process with? And then also just when you've registered a document, maintaining or updating that registration. So if the client changes their superannuation nomination, okay, or lapsing nominations, those sorts of things, your work kind of ends at the point where it's in, and then the client is then responsible for maintaining or updating any changes to things that are registered with third parties. So I think that's the major kind of essential clauses. I know that we've gone a bit deep there, but certainly if you've got any feedback, feel free to send it through. As I said, I'm already buzzing with some ideas for 2.0. We would love to hear from you. What I do want to talk about is this position around ethical considerations, because I can feel that there might be people in the comments going, oh, that's horrible, or ethically you can't do that, or whatever else. And I've got my Batman slide here as a really important part. Having the power to do something doesn't mean you should do it. And this comes from my love of the movie The Dark Knight. And it's all about the hero that Gotham deserves, but not the one it needs right now. So it's the same. This cost agreement clause that helps you kind of do this, it might be the hero that you deserve, but it's not necessarily the one you need right now. So when we talk about these clauses, what we want to make really clear is that before you take next steps to actually enforce that clause, absolutely consider the totality of the circumstances, okay? And make a decision around whether that's something that you think is worth pursuing. Have a look at the relevant literature. Our costs agreement precedent has a really long list of all of the things that we've looked at to get comfortable on a position. We have lots of user notes to help guide you about the particular things we've looked at. So we recommend that before you enforce that, you go and revisit those, particularly if the relevant literature has changed. And then finally, contact your ethics team at your local professional body. So we have a really great ethics team at the Queensland Law Society. Obviously, I'm not particularly across all the other jurisdictions. I have spoken to the ethics team at in Victoria before, and they were great as well. And I think that when we talk about these groups, they exist for a reason. And so what I do find, though, is when you read through all of the literature, and even having spoken to the ethics team, one of the first kind of things that comes up is it in your costs agreement? Okay, so have you communicated those terms with the client? So we're saying we want to give you the power to do something and then leave it up to you as to whether you enforce it or not. That's the major sort of vibe of the ethics consideration, is that we acknowledge that these clauses aren't necessarily something you should always be applying, but we want you to have the option and the power to do it, and then make a choice based on the relevant client's circumstances and in consultation with your ethics team as to whether that's appropriate. Now, I'm aware we've got some short time left. This probably is something that's more Tara's position about delivering your terms in a pretty way, is what I'm using my phrase. So when we talk about how you actually deliver the terms of your costs agreement, what I wanted to do is to tell you, give you the permission to think outside the box, okay? If you've come from a stuffy old law firm that have always done it XYZ way, you don't actually have to do it that way. I'm giving you the permission to go and find a new way to do it, okay? So when we talk about it, I want you to think critically around electronic versus hard copies, okay, and what's right for you and your practice and the client, all right? So there's lots of beautiful softwares out there for electronic that even have things, which is my next point, about integrating payment, okay, into your actual cost agreement so that the client can make that payment into your trust account. So looking at those options that work for your firm and your client. I mean, I've just had one recently where even though we do electronic signing of cost agreements, the client is elderly. I'm taking the hard copy with me to an appointment with them, okay? So there are times where, you might do it electronically, but I think having a think about those times when the hard copy makes sense. So really thinking critically around how you're delivering it to make it easier for the client. And my final point is always people eat with their eyes. So yes, we have all of this kind of protection and legal jargon written down there, but it doesn't mean it has to look really boring, okay? Put some thought and some creativity in the way that you're doing it. Set it out really clear. I know that there's some psychology around actually how you set things out to make people appreciate it a bit better and give them the brain space to have breaks. So I find, Tara, and this is something that you might have more feedback in, test it. If you've got a new one and you're drafting it up, send it to your best mate. Tell them to give you the good and the bad, but try and make it something that the client can easily review so that, number one, they're actually reading what you've given them, but number two, it's something that doesn't feel like a kind of a negative, stuffy law position, okay? Tara, did you have anything you wanted to add to that?
Yeah, just because you're like in Queensland, Lexon gives us a template cost disclosure and they say put your hourly rate and your fixed fees embedded in the document on page 5 in a paragraph. That's not written by someone who understands human design and behavioral economics. You do not have to do it that way. I much prefer like an aesthetic looking price list, or you don't even have to have them sign and accept and return the cost agreement terms. They can have implied acceptance built into it as well. So, take inspiration. The wedding industry is great. Photographers are great, digital agencies, they've all innovating on this front and making it super easy to work with them. Carrie, we're right on the top of the hour. Is it my turn to talk about our
turn. Tag you in.
Okay, so if you're loving, picking up what we're putting down in terms of the cost agreement terms and, maybe doing a bit of an audit of what you're currently doing versus that checklist I gave you and thinking it might be time to tighten up a few things, we have actually got a resource for you, which is our estate planning pricing toolkit. So this is it includes the cost agreement terms, but it actually includes a whole lot more. Like we've got a lot of training on pricing and what you should be charging for your estate planning packages, on the concept of value pricing and the theory behind that. We've also got price list templates as well that are in Word and Canva that you can rebrand. We've also got, the numbers behind the scenes. So there's a training from an accountant, Andrea from Dream Accounting, who came and talked to us about how do you actually make sure that you are charging enough so that at the end of the year, you've paid your tax, your GST, your self-super, and you still have enough take-home pay after you've made your profit. And she's even given us an incredible spreadsheet calculator tool to work out, if you want to take home this much annual pay, what do you need to be charging per matter? And of course, including all of that is our our cost agreement precedent as well. So we've got like nearly 20 pages of terms that you can just select which ones you haven't covered off, drop and drag that into your existing price disclosures and get your protection up. So I'll drop the link in there for anyone who wants it. The price is $4.95, including GST. And if you're in the TT Precedents Club, remember you get a 10% discount. So touch base with us if you need that coupon code. But this is just really meant to make the pricing part from, protection through to client engagement super simple and easy to help you make your estate planning matters more profitable. So, oh yes, we've got the testimonials. So yeah, we've just had a bit of feedback. We've only launched this since November, but we've just had some great feedback from people who are using it just to say, like it really has leveled up their cost agreement and their protection. But yeah, Carrie, that's all I wanted to say. And I think unless you have anything else, we might wrap it up. Everyone's been really generous with their time so far, and you've got a hot seat to run to.
We do. Thanks everyone for joining us, and we're looking forward to hearing from you.
Thank you. Bye.